The Honorable Court of Appeals is now in session.
Good afternoon and welcome to the Court of Appeals. First of all, I want to thank each of you for agreeing to participate in this oral argument via Zoom. It's a little different for all of us, and we appreciate you participating with us. We are live streaming, which means this is going out over the internet to anybody who'd like to watch it. So please be aware of that. And even though we're not in the courtroom, we want to make sure that everyone realizes that we're following the same rules, procedure, and protocol as if we were in the courtroom. So please think of yourself as being in the courtroom at all times. Each side will get 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time previous with the clerk, you'll receive that rebuttal time. If we experience any technological problems, don't anybody get too excited. Just stay with us. We will get those problems taken care of, and we'll make sure that no one is prejudiced as a result of that. Before we start, though, I want to introduce our panel. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Angie, anything we need to take up before we get started?
No, Your Honor.
All right, call the case, please.
Stacy Renee Lofton versus James Warren Lofton.
Thank you, and we will hear from the appellant.
Good afternoon. Thank you, Your Honor. May it please the court. My name is Ryan Hall for the appellant James Warren Lofton. This court should reverse and remand to the trial court for primarily two reasons. The first is that the court erred in classifying, valuing, and dividing the parties' assets and debts. And regarding the trial court's alimony award, this court should vacate and send this back to the trial court for consideration of an award of rehabilitative or transitional alimony. First, regarding the error regarding classification, valuation, and division of the parties' marital assets and debts, if I may begin by addressing really the key component of the marital estate or the primary issue in this case concerns husband's railroad retirement benefits. And firstly, of course, railroad retirement benefits are treated a little bit specially in the law as opposed to other types of marital assets. And according to the Railroad Retirement Board rules, for division of a railroad retirement annuity, and the parties are required to be married for 10 years before the other spouse is entitled to any of those benefits. In this case, the parties' divorce trial occurred before they had been married for that 10-year period. So they have not been married 10 years at the time of the divorce trial. The court's order, the trial court's order, however, did divide some of husband's railroad retirement benefits.
Were they married for 10 years at the time the final decree was entered?
Yes, Judge Golden, they were married for 10 years at the time the final decree was entered. That is correct. However, the statute regarding what the trial court is tasked to do in a divorce case, 36-4-121B1A, requires that classification and division occur as near as reasonably possible to the final divorce hearing date. And so in this case, at the time of the divorce trial, because the parties had not been married 10 years, the classification of husband's railroad retirement benefits were appropriately his separate property. It was only because of the delay between the trial and the later entry of court order that the classification of those assets changed. And because there's a delay, that should not result necessarily in a windfall to a party that happens to benefit from that delay. So at the time of the divorce trial, consistent with how the trial court was tasked with valuing those assets, they were not appropriately considered as marital property because the parties had not been married 10 years. But the trial court's order treated those assets as marital property. And of course, we got the result that the trial court ordered regarding a percentage division of husband's railroad retirement benefits. And specifically to that point.
Why is that any different than, let's say, the trial court is dividing a stock account and the account either goes up or goes down between the time that the trial court rules at the divorce hearing and the order is subsequently entered some month later, or however it may be? If it goes up, there's more money to divide. If it goes down, there's less money to divide. How's that any different?
Judge Stafford, most of what I'm familiar with trial court orders of that nature, most of the time the order would reflect that there's a valuation as of the date of trial. The trial court orders a division together with any gains or losses that occur after the divorce trial in the period between the divorce trial and the entry of the final decree. And those are due to market forces. But in this case, specifically regarding the railroad retirement benefits, the only thing that changed was the period of time that elapsed. And it's not a situation where the assets are gaining or losing value due to market forces. It's a situation where the actual classification and whether there is any right of one spouse to receive those benefits changes simply due to the passage of time. If I may briefly address the issue about there being approximately $128,000 of husband's railroad retirement benefits that were divided by the trial court. Based on the financial affidavits and list of assets and debts provided by each party, they appear to be referring to the same asset because the dollar amount is approximately $128,000. They label it differently. Husband calls it a railroad 401k. Wife refers to it as a CNUS savings account. And the court subsequently divided that based on that percentage division where wife receives 33% of the benefits. But to the extent that $128,000 contained any tier one benefits that are not divisible, then that award was inappropriate. And based on the record, there's no finding about what portion of the $128,000, if any, were either tier one or tier two benefits. But there are findings in the record, and you're able to determine from the record that tier one and tier two benefits did exist.
But there was nothing. Was there anything in the record to indicate that those funds in that particular 401k account had anything to do with the tier one or tier two benefits? I saw a pay stub that reflected tier one and tier two benefits, and then there was additional money going into the 401k. That was a totally different account from the regular pension benefits, wasn't it?
Well, there was based on paycheck stub, there's a 401k deduction that's occurring. Husband in his list of separate property refers to a railroad 401k plan. Wife has a different name for that on her balance sheet.
But so, I mean, there was also different designations for tier one and tier two benefits on that stub as well, wasn't there?
Yes, Judge Golden, on the earnings statement, there was different entries for tier one and tier two benefits.
What I'm trying to understand is, I'm trying to understand your argument, because it's my understanding from the proof is that was an entirely different benefit. That that had nothing to do with the tier 1 or tier 2 retirement benefits. That was a separate account that had nothing to do with that. It was a 401k plan, presumably, according to your client. So I'm not sure what the argument is about tier 1 and tier 2 as it relates to that plan.
The argument is simply based on the record. Someone has to make an inference about the 128,000 and whether part of that is tier 1 or part of that is tier 2.
Why?
So the basis.
Why do you have to make that distinction if there's nothing indicating that it's tier 1 or tier 2? The distinction was made on those benefits that were designated tier 1 and tier 2. But I mean, this 401k, what's the difference between a 401k with the railroad and a 401k with any company? There's nothing indicating that anything, there was nothing indicating in the record that there was any distinction between, or that there was a distinction in the 401k versus tier 1 and tier 2 benefits, as I understand it. Those were separate retirement plans, as I understand it.
Trial counsel later filed a motion to address the concern about whether that $128,000 included any tier 1 or tier 2 benefits, because the court in its order ordered the division of the $128,000 based on the percentage calculation of years of credible service and duration of those years of service during marriage. But to answer your question, it's not clear from the record that those benefits are tier 1 or tier 2. I'm out of time.
Well, let me ask you this. You're aware that the Canadian National Railroad and the Illinois Central Railroad are the same railroad?
I'm not aware of that, Your
That
Honor.
all of those benefits are for that's the same employer. You understand that? Did you know that?
No, Your Honor, I didn't know that. It based on, well, there was a finding about husband's service for Canadian National Railroad when he started and how many years of service that overlapped with marriage. But there was not a finding about his start date at Illinois Central Railroad,
That's the same company.
or whether those were the same employer based on the record.
All right.
All right, we will hear from the appellee.
Good afternoon, David Hamlin from Union City. I'll start where the appellant started, and that was where they married 10 years. The statute for the railroad and the retirement didn't say you had to be married 10 years when the trial was heard. It said you had to be married 10 years. They were married 10 years after December the 28th, 2019. The court order was entered February the 3rd, 2020. And according to Tennessee Rules of Civil Procedure, when a final order is entered, that is when it becomes final. That is the order of divorce. That is the final decree of divorce. And they certainly were married 10 years when the order was entered. Counsel argues, well, we should go back to the day they tried the case. When we tried the case, this issue came up about the 10 years for the first time. And I certainly did not know anything about the railroad retirement system's 10-year rule. Neither did the chancellor. And so I requested a little time to review that, to find out more about that issue, as did the chancellor himself, because he didn't know anything about it. So we were granted a few days to look into that and submit whatever information we could concerning that 10-year issue. We did that. Upon submission of those findings, the court entered an order on February the 3rd, 2020. That's the end of the 10 years.
When did the court make a decision about that? Was that the February 3rd order?
Yes, sir. That's the first time it was addressed.
Okay.
So they were married 10 years. I mean, that's just not hard to figure out. You figure out the 10 years is when the order was signed. That's when it became a final decree of divorce. It'd be like if you wanted to have a case heard and then you had to come back and continue the case for a decision or any reason. That's not a final order. That's not when the case is over. The case is over when the final order is entered. So that's February the 3rd. Now, this Canadian Railroad Savings Plan, this $128,000, the judge did not order that she was to get any part of $128,000. The judge ordered that she was to get 33% of all tier 2 benefits. That's all, whatever those benefits were. And we won't know that until we send in our quadro for that amount and have that amount set by the railroad. The judge acknowledged in his order that there are no tier 1 benefits available to the wife. She is not eligible. And the court set that out very clearly in its order. And so the only award to the wife.
Mr. Hamblin?
Yes, sir.
The final decree of divorce says that the husband has a Canadian National Railway Company savings plan for U.S. operations with a value of $128,000 less a debt of $11,000, and says that it goes on to say other things. Then it says the wife is awarded 33% of the Canadian National Railway Company savings plan for U.S. operations. That's in addition to what he awarded on the tier 2 benefits. Are you sure?
No, yeah, and I probably misspoke when I eliminated the Canadian title. I don't think, Judge, that the tier 2 benefits are distinguishable or different from the Canadian savings plan. I don't think that Mr. Lofton had separate Canadian savings plans and tier 1 or tier 2. I think all of that is the same plan. And so when I say that I use those in interchangeable terms, that the savings plan and the tier 1 benefits or the tier 2 benefits are included in that same savings plan. I think that was the argument there, are tier 1 and tier 2 that comprise that savings plan. And I don't believe that's the case. I believe that tier 2 benefits or whatever, and I may be mistaken about this part, but I think the tier 2 benefits are part of or all of the Canadian National Railroad Savings Plan. And if that savings plan does constitute both tier 1 and tier 2, then the railroad will only be able to award 33% of the tier 2, not any part of the tier 1. And so, we don't have a breakdown, and there's been no way to know exactly if that is a combined savings plan or if it is separate. So, and I heard you ask a while ago about the 401k, and that term is used in his check stub, and it looks like it's a 401k union employee benefit. And I don't know, Judge, that is separate from this Canadian plan. I think that is all the same. And that may be something that you want us to go back and look at. But that, when we were in the trial proceedings, my understanding was from Mr. Lofton that this was all one savings plan. Not having the benefit of the transcript here, I know y'all can't figure that out, and I can't tell you, but during the trial of this case, when the judge had the opportunity to hear the witnesses and to make whatever notes he could make in the process of a trial like this, it's my understanding that the savings plan is the Canadian National Railroad Savings Plan, which constitutes all of Mr. Lofton's savings, including tier 1 and tier.
Did the court draft its order? Did the court draft its final decree?
No,
Final
sir.
order of divorce?
No, sir. I drafted that based on a letter memorandum from the court that just gave us the bare bones of what he ruled. And then I drafted that order, and I put in that order, I actually called the railroad and found out that I had to put certain language in the order for them to be specific as to what savings plan they were to take the quadro from. And so, no, sir, the judge did not draft his own order. He just drafted a memo letter.
All right.
In regard to the division of the assets, and they didn't go into that too much, but I think the only really asset they're arguing about is this savings plan. In their brief, they argued a bunch of other stuff about some more stuff, but I don't. That wasn't brought up today, so I don't know that it's necessary to go into that. But I think we've addressed the savings plan and the length of marriage, which probably are the two most important things that the court should address. And unless there's something that the court did that was clearly erroneous or clearly not reflected by the evidence, this court's not probably going to be looking at that as a case where they would interfere with the court's decision, having the court listened to all the witnesses, observed the witnesses, and ruled from the testimony. And I know this makes it harder on us, and I know it makes it harder on y'all not to have the transcript, but I believe the judge's decision about all of the issues that we've addressed today is covered in the statement of evidence and the exhibits that were listed. And I believe that the court correctly ruled on the issues. Now, one thing, they didn't bring it up today, and maybe it's going to be later, but they're arguing about this $1,000 a month. And he didn't have enough money. We didn't get into that today, but my brief sets out very clearly that he had sufficient income to pay this $1,000 a month. And what Mr. Lofton didn't take into consideration was the amount of gross income less what actual expenses that he would be entitled to deduct. And he totally deducted everything. He just took every deduction that was listed on his check and took it off of the gross, and that left him with a $5,800 and change. Well, you can't take all of those expenses off, but some of them are non-deductible. Some of them are voluntary payments that he's making on his own behalf, and those were not deductible. And then he had these expenses for
Mr. Hamlin, Mr.
Yes.
Hamlin, did the court make specific findings as to the husband's ability to pay, in that finding numbers as to what the husband's income was and what his reasonable and allowable expenses were, leaving him with any type of a net number? Did the court make any specific findings on that other than to say that he was capable of paying alimony?
I believe the order actually stated how much money he had in gross earnings. I believe the court stated that he had gross earnings of $62.95, and then he only stated that he had reviewed and considered all of the factors concerning the alimony, and he did not list those factors, nor did he list in specific detail the monthly expenses. And I think when you look at that, you're talking about alimony, and of course, Buchanan sets out the standard for the courts to review any alimony determination, and unless it's the trial court applies an incorrect legal standard or reaches an illogical result or relies on clearly erroneous evidence, then the appellate court should presume that the decision is correct. And of course, y'all know more than I that you don't go back and redo the decision once the trial court makes that determination if those abuses did not occur. So
One other question for you, Mr. Hamlin. Did the trial court put a value on anything other than the retirement funds and I believe a 2006 truck? Did the court find any valuations as to any of the other items of either debt or property that the court divided?
I don't believe that the court went through a line item and assessed any value to anything, except the court stated that that the parties had divided their assets per their affidavit of income, affidavit of assets and liabilities, and that the parties had separated and divided their personal property, except those three or four items that you spoke of. And so he did not go back and do a line item on each asset. He took the parties' agreement that they have divided and separated their personal property, except for those items in dispute, and he disposed of those himself. The truck, he disposed of. The TVs, he divided those one each. I think there was a lawnmower or something else. There was a 401k debt, or a tax debt, not a 401k, a tax debt, and the savings plan. So I don't think, ma'am, that he went through a couch, a chair, a table, and put values on anything. He took the parties' statement of evidence and affidavits as to what they assigned to each of those items.
Thank you, Mr. Hamlin.
And I believe I have covered everything that was brought up today, and I'll relinquish my time.
All right. Thank you, Mr. Hamlin. We'll hear from Mr. Hall in rebuttal.
Thank you, Judge Stafford. And if I might address the question that Judge McGee raised about the trial court's specific findings regarding husband's ability to pay alimony. On Trial Exhibit 2, which was part of Volume 3 of the technical record, it appears that the trial court made a handwritten notation on husband's affidavit of monthly income and expenses that he would have $500 more dollars per month, or in other words, he would not have a $500 housing expense upon the sale of the party's residence. So there was a finding made about that that supported the trial court's order that husband should pay alimony. However, as I pointed out in my brief, that overlooks the fact that husband would reasonably have some other housing expense. And there was no consideration of other housing expense that husband would have in relationship to an award of alimony. Also, whether you look at husband's year-to-date paycheck stub that was submitted at the time of trial, or based on earnings in prior years, if you take those net earnings and then you subtract from that the expenses that husband submitted at trial that the trial court did not make any findings about other than this $500 a month housing expense that I discussed, then under that scenario, husband would have a shortfall monthly and would not have the ability to pay the alimony as ordered by the court. And if I may,
didn't the court in its letter ruling of July 31st lay out what Mr. Lofton's gross earnings were and what the expenses were, and the fact that the court questioned the amounts being set aside for the 401 and other deductions? In other words, he said he had like over $3,500 in payroll deductions, but he had $3,300 in monthly expenses from gross earnings of over $6,300, and the court was questioning the these other deductions other than his monthly expenses of over $3,500?
Yes, Your Honor.
That was in the letter ruling, wasn't it?
Yes, Your Honor. But as far as what the reasonable expenses the trial court may have found that husband would have, there's no finding about what his reasonable expenses are. There may be a question about certain payroll deductions or a question about, his housing expense. But what the court ordered was that he had the ability to pay $1,000 per month in alimony. And as to
what the ruling says is he's referring to Mr. Lofton's own affidavit. He said his affidavit shows $3287.30 per month in expenses. So he's relying on Mr. Lofton's own affidavit as to what his monthly expenses were. What he questioned was the $3556.75 in payroll deductions, which included money that goes to the pension and the 401k and these other deductions, as to whether or not all of those, he had a question about those, but not as to the expenses. It looked to me like he gave him credit for all of the expenses. This expense amount was taken from Mr. Lofton's own affidavit.
what we can't determine from the record, unfortunately, is what control, if any, husband has over, for example, the tier 1 or tier 2 retirement payroll deductions. We're unable to determine whether he has any control over how much the Railroad Retirement Board deducts from his paycheck regarding
What about
those
401k
deductions.
contributions? Does he have control over 401k? Those are voluntary, aren't they?
Those would be voluntary. He would have control over those. Yes, Your Honor.
All right.
And briefly, in the time I have remaining, and I'll try to quickly summarize, regarding wife's need for alimony. In this case, she had a disability, no doubt, but regardless, or rather in spite of that disability, she had an established work history, which is sort of unusual in the sense that you don't see that in some of the other cases. And I'd ask the court to consider that. Thank you. I'm out of time.
Thank you.
All right. Thank you, gentlemen. We will attempt to get an opinion to you as quickly as possible, and we will take this matter under advisement. We appreciate you participating with us via Zoom. Ms. Angie, if you will recess court to the call of the next case, please.
This honorable court is in recess until 3 p.m.
Thank you.
Thank you.
Thank you.